Everybody ready? Good morning. This is the Committee on Law and Government. We just got off the bad start by somebody mentioning the Eagles, but you know. We have attained a quorum with Vice Chairman Councilman Green, Councilwoman Bass, Council President Clark, and Councilwoman Sanchez, and Councilman Doms standing by here. Thank you. Ms. Marconi, will you please read the title of the bill and resolution before us?
Bill number 190861, an ordinance providing for the submission to the qualified electors of the City of Philadelphia, a proposal set forth in a resolution approved by council of an amendment to the Philadelphia Home Rule Charter to revise and clarify the restrictions on city officials and employees respect to political activities. Resolution 190874, resolution proposing an amendment to the Philadelphia Home Rule Charter to revise and clarify the restrictions on city officials and employees with respect to political activities and providing for the submission of the amendment to the electors of Philadelphia.
Oh, thank you. Before we have our witnesses, Chair recognizes Councilman Green, the sponsor of this bill and resolution.
Thank you, Mr. Chair. The purpose of this hearing and this conversation is something that was brought to my attention, something I've been familiar with for some time. Various city employees have raised a concern about the fact of their inability to participate based on either freedom of association or other constitutional rights, and feeling that our local prohibition on political activity is too restrictive. So this has been a conversation I've been engaging in the past few weeks with both members of Ethics Board, staff, and also Law Department, others as well at the Committee of 70 to start this conversation. I felt the conversation was needed at this time. Based on some of the conversation we've had, desire was to hold this bill to provide the various parties to have more opportunity to continue this conversation. My goal is to reintroduce this as we come into 2020 so we can continue the conversation, have a more fruitful dialogue so that all parties and stakeholders will have the opportunity for their voices to be heard and to have a fully deliberative process. Thank you, Mr. Chair.
Thank you. Ms. Marconi, our first witness, please. Oh, I'm sorry.
Michael Cook.
Ms. Cook, please approach and identify yourself for the record and proceed, please.
Is this on? Yes.
Yeah, there you go.
My name is Michael Cook. I am the General Counsel for the City's Board of Ethics, and I'm here to testify today on behalf of the Board. With that, good morning, Chair Greenlee, Vice Chair Green, and all the other members of the committee and the council members who are here today. Thank you for the opportunity to speak on this bill. We have submitted written testimony, so I won't go through it word by word, but we'll
Thank you.
Yes. A brief summary of the board's point of view and thoughts on this legislation. What I would say is that the board notes that the proposed legislation would revise the political activity restrictions that are found in Section 10107 of the Charter in order to allow city employees to participate in campaigns of candidates for non-local, statewide, or federal office. Proposal would also includes provisions prohibiting city-appointed officers and employees from engaging in political activity on work time or while using their city title or city resources. I would note, of course, that those restrictions are already the law as found in the board's political activity regulation, Regulation number 8, which sets forth a detailed interpretation and guidance of the relevant restrictions in the Home Rule Charter. And also note that the board recently updated Regulation number 8 in order to ensure that the restrictions that are in the Charter aren't interpreted in a way that's unduly restrictive of city officers and employees' ability to engage in personal political expression and activity. For example, there's quite a lot that city employees can currently do. They can attend campaign events as a spectator, display candidates' lawn signs at home, wear political buttons while off duty, or not in uniform, give money to a candidate, political party, or political group, campaign for or against ballot questions, and participate in political activity with unions, civic organizations, or partisan political groups, and may also express their personal political opinions and beliefs in their off-duty time. But it is certainly true that under the current rules, appointed officers and employees are not permitted to participate in political campaigns or take part in the management or affairs of a political party. So as council considers changing or loosening those restrictions, the board would just note that they believe, and we believe, that it is important to keep in mind that the drafters of the charter in the middle of the last century found and felt that the political activity restrictions that are in Section 10107 are an essential component of the charter and were designed to help make sure that the vision of the new city government that they were creating through the charter would be effective and answerable to the citizens of Philadelphia. And really they saw the whole charter, but Section 10107 in particular, as a remedy for the preceding decades of mismanagement, waste, corruption that had resulted from the subordination of city government to machine politics. And so with all that history in mind, the board, of course, believes it is very important to take great care in making any changes to these provisions, since we wouldn't want a resurgence of any of those problems. And to that end, certainly appreciate council and council member Green's decision to start this conversation, to take time to explore the ramifications of these particular changes, and noting, as he said today, that it wouldn't be moving out today, I think gives time for that very important conversation to happen. And recognizing, the board recognizes that, of course, it has been 60 years since the charter was put into place, and it makes sense to assess whether or not the restrictions that were put into place back in the early 50s still match the needs and realities of the city, and that seeing this legislation as the beginning of that conversation to fully assess what might be appropriate, what is happening in other jurisdictions, and so on, seems like a very worthy goal and approach to these particular issues. So with the understanding that the legislation is not going to move today, I will conclude my testimony there and note that the board and staff are very happy to continue this conversation with council as we and council assesses the appropriate measures under these provisions of the charter. I'm happy to answer any questions you may have.
Please let the record reflect committee members, Councilman Jones and Councilman O have been present. Councilman Green?
Thank you, Mr. Chair. This was actually...
No, go ahead.
Go ahead.
No, just, also Councilwoman Kim is here too.
Thank you, Mr. Chair. I went back and forth on whether they introduced this legislation at this time. This actually was brought to me by a city employee who was concerned based on their inability to participate in a campaign, especially a presidential campaign. And part of the concern, and I want to get some of your perspectives on some of these issues, that the timing of this also didn't want to get caught up in the fact that, you know, we have our presidential primary in April in Commonwealth, Pennsylvania, and so did not want this to be viewed in any way supporting one presidential candidate or not. So that's why I kind of went back and forth on whether do we wait till January or do we at least start the conversation now. And so that was part of the challenge in reference to introducing legislation at the time that it occurred. But I want to get your perspective on just a few things. Currently, would you say that and I'm glad you gave some perspective on the history of the Home Rule Charter and the prohibition on the activity was done back when this was enacted some 60 years ago. But how would you compare our local restrictions to other jurisdictions around the country?
Well, I would say that across the country there is a pretty broad spectrum of political activity restrictions as applied to governmental employees. There are some jurisdictions that don't have any rules, really. There are many jurisdictions that limit the restrictions to the political activity of city or state, municipal, or local employees while they're on duty, and then say when you're off duty, you can mostly do whatever you want. And then there's a group that includes Philadelphia that are more restrictive and include prohibitions on certain types of political activity even when the government employees are off duty. And so on that spectrum, I think that Philadelphia is certainly on the stricter end as compared to the whole swath of government entities around the country. I wouldn't say, though, that it is unique. It has some company in terms of the level of restrictions that it has.
Right, but you would agree definitely on a stricter sense. And wouldn't you say that our local restrictions are more restrictive than the federal guidelines under the Hatch Act?
Well, that depends on the category. So with the Hatch Act, it has two tiers. It has most federal employees have less restrictive rules, which are, for the most part, prohibit them from engaging in political activity on the job or using governmental resources. I believe it also prohibits participation in fundraising activities. And then there's another category that are more strictly restricted, and their rules are very similar to what we have in the city, and that's folks who work on elections or national security or in more high-level and sensitive positions. So they have the two tiers on the federal government. Most federal employees, though, have less restrictive rules than city employees in Philadelphia have.
And then also, just want to get some perspective, because I think there's unfortunately a lot of misinformation locally. For example, you have a number of city employees who believe they can't even sign a petition for someone to get on the ballot, which is also not true, correct?
That is correct.
Right. And so, from my perspective, I think this conversation is important because you have those perspectives. You also have city employees who don't realize that they can actually, on their own time, as long as they're not in anything that identifies them as a city employee, as long as they're not saying they're a city employee, they want to create their own campaign material for a specific candidate, they can do that on their own time. The key is it cannot be coordinated with an official campaign.
That is correct.
Right, and I think many people don't even have that perspective. They take the perspective of, I can't participate in anything, I can't even sign a petition, the only thing I can do is vote. I think a number of people don't even realize that if they want to make a personal contribution to a candidate, they can do that. If they want to, as I said a few moments ago, create their own campaign materials and say that I want Councilmember Bill Greenlee to run for president. Not saying you're doing it. But they could, but if they want to do that, they could do that on their own time. The key is that they cannot associate in an official capacity with a political campaign. And I think part of that is also one of the reasons why I think this city employee reached out and said they had these concerns. Because we have such a low participation rate, we just came out of a general election where our participation rate was not nearly where it should be. That trying to get more people involved in the process is a good thing, but at the same point, knowledgeable about the history and the concerns that people have from what led us to this point at this time.
Yes, I think that's a great point, and something that we at the board are very cognizant of, in particular with the recent updating of the political activity regulation, which coincides with, over the past couple months, initiative on our part to expand our training programs in order to try and have as much of our training as possible be communicated by board staff directly to city employees in order to try and make sure that people have the accurate information on what the rules actually are. It was about 10 years ago, until about 10 years ago, the charter was interpreted in a much stricter way that essentially prohibited city employees from doing anything involved with political activity. And I think there has been a persistence in the understanding that those are still what the rules are. And so we are very keen to make sure that city employees know what they actually can do, because there is quite a lot that they can do. And so we completely agree with you, the importance of making sure that city employees are properly informed about what they can engage in.
Thank you, Mr. Chair.
Thank you, Councilman. Councilwoman Gimm?
Thank you very much. Good morning.
Good morning.
So I also want to thank my colleague for being willing to hold movement on this bill, because I think it is an important area for us to continue to discuss. I appreciate the work of the Ethics Commission to continue to work with different actors and specialists in this field to ensure that we are continuing to define and modernize regulations around this original provision. But I'm wondering if you can tell us a little bit, and with being delicate about age and everything, I don't profess that you were there at the time, obviously, but I wanted to know if you could talk a little bit about the origins of the original bill. What was happening at the time in city government that sort of inspired some of the strictness of this ruling? Because it was my understanding that there was flagrant violations of what we would consider to be appropriate use of government responsibilities.
So I would just caution that once you get me started on this topic, I might go on longer than the chair of the committee would like me to. But I will try to. I will endeavor to be brief. It's actually a very, very interesting history and stretches back decades before 1951 into the late 19th century, which is where you really saw the development of the machine political culture in Philadelphia, where city and county government essentially became an appendage of political parties. And the result, there was multiple bad things that happened. I mean, there was on the one hand a fairly high level of violence that occurred around elections, in particular, or perhaps most notably, in the 1917 municipal elections, when competing candidates for the Republican nomination for the 5th Ward Council seat brought in muscle from outside the city to intimidate and rough up people, and resulted on Election Day with a killing of a police detective and a serious assault on one of the candidates, which led to the mayor of Philadelphia being indicted for murder, along with a council member, a member of the state legislature, and various other people. The mayor was acquitted at a jury trial, but others were convicted and served prison time. In 1919, the politically appointed commissioner of the health department completely bungled the response to the Spanish influenza, which led to tens of thousands of Philadelphians dying because they were herded into confined spaces where the disease was easily communicated, as opposed to people being quarantined. On through the 30s, in the 20s.
No need to cover every decade,
So
but we're getting the gist.
There is
The mayor indicted for murder is really a long step towards that.
Yeah. Issues with municipal contracting, so contracts being awarded to politically connected contractors, such as the brother of the local political boss, which resulted in massive overcharging for the city for construction and other projects. Things like the Arch Street subway, which is just a hole under the ground and was never actually used. Into the 40s, which the various things revealed by the Committee of 15 investigation, such as about 20% of city taxes not being collected, double ledger books being used in order to misappropriate money in various departments. Those revelations ended up in 4 separate city employees committing suicide as they're about to be indicted. Those sorts of things.
If I could just move the timeline up. I mean, I assume that in the creation of the charter in 1951, that there must have been some extensive conversation about the role of this particular regulation. And if you could talk a little bit about what was some of the impetus, what were the discussions, the spirit of this ruling at that time, and what was it meant to curtail? Because it certainly was not about freedom of speech or about all these other things. It was really meant as an anti-corruption tool, as I would understand it, and that there needed to be explicit, that there had to be something more explicit in place in order for corruption to both, one, be defined, which was not clear, and two, to be curtailed.
Yes, certainly. Many city employees owed their city position to their participation in political activity, and were expected to routinely engage in political activity even after they had gotten the jobs. Twice a year, people came by to collect money from every city employee to fund the political operations. And so the city governance became secondary to the needs of the political party. City government employees were seen as tools of party politics. And so the goal of the provisions in the charter was to put a really significant barrier between the party politics and the city governance so that those situations wouldn't arise again.
It actually wasn't even all that recent. I know that one of the issues we were dealing with in the mid-2000s with the Bureau of Revision of Taxes, for example, were that these were BRT employees who were put on the school district payroll, for example, so that they could hold political positions within political parties, because the restrictions on school district ethics were mostly non-existent. I still think they're very slim right now, and did not prohibit political activity. So there was seen as an effort to evade things so that effectively individuals who should be city employees and who are today, thanks to the work of folks like yourself and others, in between 2006 to 2010, I think it was made a concerted effort to really change that around so that they would become full city employees subjected to that, would no longer be seen as, for example, property tax evaluators going out and holding political positions for individuals who might be caught up in other types of things. So in fact, that history is not all that long ago.
That's right.
One of the things that I also want to ask, the regulations take a look at whether we should only focus in on state and national. I'm curious about your opinion about whether state politics is also still too close in the largest city in the Commonwealth of Pennsylvania, and probably the most significant city in the Commonwealth in terms of voting and et cetera, et cetera.
I would say that it certainly raises the concern for any office holder who is elected out of Philadelphia and serves the people of Philadelphia particularly. So members of the state House of the State Assembly or members of Congress for the House of Representatives, those folks are very closely connected to city life, and there, in my experience, is a fair amount of interchange between those individuals as candidates and office holders and the life of the city, whether the governance of the city or just the day-to-day life of the city. And so I think that is something that it would be a good idea to think very carefully about where to draw those lines.
And there's been questions about free speech, obviously, like restrictions on free speech. And I think that one of the things that's been really helpful is that you've outlined many different ways in which new regulations evolve the understanding, and our work obviously is to inform our employees that they do have the rights to these types of things. But I'm also curious about where you think you would draw the line, and I do think we need a number of ethics experts and professors and other types, and I know we have one who will be testifying. But where you draw the line between an individual who would participate in campaigns or elections that would, in the opinion of some people, run counter to a good government mission, a government for all, for example. And do you see any concerns around that? So, for example, if there were to be a candidate who were to espouse views that would be counter to, for example, a sanctuary city policy that the city has, and they are in charge of running certain things? Could there be lots of questions or concerns from ordinary citizens or people who are asking for services of that agency, whether they would get a fair hearing or viewpoint in front of this agency if it's being chaired by somebody who then is, for example, the chair of the campaign, for example, of a particular candidate who would seem to be in counter to those responsibilities? How does free speech work in that context?
Yeah, and certainly the rights we have under the First Amendment for free speech and association are what we all want to ensure is protected and that people aren't unduly limited. That in mind, though, the courts have routinely held over the years that it is appropriate and permissible for governments to limit the exercise of those First Amendment rights by governmental employees precisely in order to address the kinds of situations that you're talking about. So to ensure that government services are free from corruption, that the citizens feel confident that their government decisions are being made for the best public policy reasons, not because of political persuasion or political influence, to give people the faith in government that they need to have. And so long line of cases that have permitted municipalities or states or the federal government to limit the political activity of government employees in order to avoid just those kinds of problems.
Yep. So under our current regulations, a city employee is allowed to donate money, can express political inclinations, they can hang signs in windows, they can sign petitions, they can distribute individually, independently created candidate materials, they can be loud cheerleaders, but they can't hold formal positions, for example. So what we're saying no to is like the ability to hold formal positions within campaigns in the management or direction of affairs. They can't, for example, they can't run the finances of a campaign, right? So they can't solicit or force a solicitation of money. And they can't, for example, fundraise on behalf other than your own donations that you personally do. Is that correct?
That's right.
Okay. And if we were to loosen these restrictions, and one of the concerns is, for example, could there be a scenario in which a police commissioner could become the chair of an attorney general's race, the campaign chair of an attorney general's race? That could potentially be open. Is that correct?
I believe that would be permissible under the proposed legislation.
Could, for example, a Parks and Rec commissioner who is hired by a mayor who decided to step down and run for governor, could that person then become the finance chair for that gubernatorial campaign?
Well, if had the person resigned city position in order to run?
No. Under these guidelines, I assume resigned to run. Is resigned to run eliminated?
That's not
That's
my
not
understanding.
the discussion in play right now.
No.
So assume resigned to run is in place. So resigned to run is in place, and a former mayor or a current mayor who hired a Parks and Rec commissioner, for example, steps down to run for governor. That Parks and Rec commissioner could become that person's finance chair, or the managing director could become that individual's finance chair. Is that correct?
I believe that is correct.
Or the commerce director.
Yes.
So some of these things that may be seen as being like broad protections between like the state is here, the national is here, they're so removed from municipal office may not be that far removed.
There would certainly be the opportunity for folks who are currently not allowed to participate in campaigns to do so regardless of what their position in the city was.
Right. Okay. Thank you very much.
Thank you, Councilwoman. Councilman O?
Yeah, thank you very much. I just want to make sure there are different types of employees that work for the city. We're primarily talking about civil service employees.
So these restrictions apply to all city employees and appointed officers. So they do not apply to elected officials, but they apply to everybody else, not just civil service, also exempts and most or a significant number of board and commission members.
Okay. And these rules do not apply to the court system,
Correct.
and they don't apply to authorities like the parking authority,
Correct.
and they don't apply to state government employees in the city of Philadelphia,
Correct.
nor do they apply to federal employees in the city of Philadelphia, just city employees.
That's correct.
Okay. So part of what happened as a result of the charter, the charter that was created to deal with macing and bullying of city employees was, as I understand it, a compromise that they would try to do good government within the city government itself, but leave patronage positions in the courts and other places pretty much untouched. Is that your understanding of the history, or?
No.
Okay, what is your understanding?
So the city charter would only be able to apply to city officers and employees, and there was quite a lot of litigation in the 1950s about who was in and who was out, but the courts, state employees, they're just not covered by city law, and so the city charter wouldn't be able to reach them. As to, for something like the parking authority, the other authorities, the creation of those entities and the decision about whether they should be authorities and therefore state employees or part of city government, it may well have been part of that decision or a factor in that decision, like, well, if they work for the state, then they won't have these rules, as opposed to if they work for the city. That I don't know, but regardless, it's only city officers and employees that can be covered by the charter.
So while the school district is a separate governmental entity, but its governance is controlled by the charter.
The charter has various provisions related to the school board and the school district, but as you said, it is a separate political subdivision, and so it's not, their employees are not considered city employees.
Right, but is it the case that a charter change on the governance of the school district could implement in the creation of the governmental or the governance board ethics rules similar to the city in the school district among its employees?
That I don't know, because I don't know the limits of the city's ability to create rules, whether under the charter or under ordinance with regard to the school district, but it's possible. We'd have to check with the law department about that.
So currently within the city, we have, for example, a very different system. For example, a state legislator and their staff and state employees would not be subject to the city rules, but city employees are. And so the current system that we have really deals with governmental employees who work for the city, but no other governmental employees.
That's correct.
And there is a at least expressed concerns that having an effort to provide a ethical standard to governmental employees should be uniform. In other words, federal, state, city, all subject to the same rules and conditions. What do you think about that?
I personally have not heard that concern expressed. I don't I wouldn't agree with that because I think that whatever the rules are for a particular municipality or state or whatever level of government should be tailored to meet the needs of that particular entity, and that different municipalities or states have different histories and different needs that they may feel different rules are more appropriate.
Okay, thank you.
Thank you, Councilman. Councilman Green?
Thank you, Mr. Chair, and thank you, Mr. Cook, for your testimony today. We've worked on a lot of this work for a number of years, going back to, well, actually right before you came to the ethics staff as one of the co-authors of our current system of campaign finance laws when I worked for Councilman Tasco. Spent a lot of time on this legislation, helping to make an improvement. Earlier was stated that a number of issues that occurred which led to our current system of campaign finance, a lot of corruption that occurred in the past, and no disrespect to my colleague, Councilmember O, but that was during the leadership of another party than that's currently involved here, correct?
Yes.
Okay. But also at that time did not have an independent ethics board as well.
That is true.
And that's part of the reason why we did that work some years ago. And so as the ordinance is drafted, this is a question for the electors of the city of Philadelphia. And basically, we're talking about their ability to participate. But even if this were on the ballot in April, there would be other legislation that would need to be drafted, just like our current ethics laws, to interpret what that participation would be.
So the board interprets the charter through its regulation number 8. And if the provisions of the charter change, then the board would need to update that regulation in order to interpret the new provisions, yes.
Right. But even so, they would need to interpret the charter. But from our working relationship over the years, when there's been issues of either gaps in the law, there's been suggestions on how legislation should be introduced to tighten up the language to make it easier and give more guidelines to people on how to interpret the law. I know in the regulations we've drafted, worked on different hypotheticals to kind of give people perspective on what they can or cannot do. So even if this were to be passed, there would probably be additional legislation to define and tighten what would be considered participation in this process.
So as far as the scope of legislation that would be allowed after approval of a ballot question, I would have to defer to the law department. I don't know how strictly the requirements are to keep to what the resolution that passes at the same company with the bill would be. Certainly, we have over the years, from the perspective of the board and from staff, had a very productive working relationship with council as a whole with regard to legislation, and certainly with yourself and your office, and would hope to continue that either before this particular legislation moves forward, or after, or down the line as any adjustments or changes would need to be made.
Even the fact that we're actually holding this bill was based on suggestions, I think, both from you, that the ethics board really didn't have enough time to fully contemplate because their most recent ethics board meeting, as well as the Compensation Committee 70 also had some concerns as well.
Yes, I think we very much appreciate the holding of the bill to allow for that additional study and conversation to get a better understanding of what the desires are and to avoid any unintended consequences or difficulties that may arise, or implementations that would be beyond what council was looking for through the legislation.
Right, because even right now under the current legislation, if a city employee wanted to volunteer for a campaign and pass out literature that was paid by the campaign, they couldn't even do that on their own time if they would like to.
Are you asking about what the rules currently are?
Currently, if a city employee wanted to volunteer in their own time, not wearing any type of insignia or information identifying themselves as a city employee, but want to pass out literature for a campaign that was paid for by that campaign, on a Sunday afternoon after church or on a Saturday morning. They could not do that unless they made up their own materials on their own behalf.
You're correct. They could not pass out anything created by a campaign. They couldn't do anything in coordination with a campaign. They could do it something they created themselves, or something that was created by their union or a civic group or even a partisan political group, but not a campaign of a candidate.
Right. So clearly, there's a large perspective from a city employee just deciding that I would like to volunteer on a campaign and pass out literature paid for by the campaign on their own time to the actual management of a campaign. So that's a large perspective of activity. Just like in a number of different cities, they have different types of restrictions, what they can do, what they can't do. But clearly, based on your earlier testimony, that Philadelphia is seen as more restrictive than a lot of other cities. And even on the federal level, the federal government provides much broader freedom of association for federal employees to participate, except for those employees in a very highly specialized area, which I think you referred to in your testimony.
Yes, that's correct.
All right. Thank you, Mr. Chair.
Yeah, thank you, Councilman. With no further questions, thank you, Mr. Cook.
Thank you.
Appreciate it. We have, for my next panel, our next panel, I have Tabitha Abu El-Hajj. Hope I didn't mess that up too bad. Pat Christmas, committee of 70. Now, the only other person I have on the list, because I don't see Shelleyano, is Richard Levinson. I'm here. Okay, thank. If you could come up front too. Is there anyone else here who wanted to testify? Okay, good. Ms. Levinson, why don't you come up too? So this will be a final panel since there's nobody else ready to testify. Ma'am, why don't you go first?
Sure.
Please identify yourself and proceed.
Yeah. Is this on?
Yes, it's on.
Yes. So my name is Tabitha Abul-Hajj. I'm an associate professor at the Thomas R. Klein School of Law at Drexel University. I appear here in my personal capacity and do not speak on behalf of Drexel University or the law school. I hold a JD PhD from NYU and have written extensively on the First Amendment and the law of democracy. And I've published extensively on the right of peaceable assembly and association, as well as campaign finance and political parties. I have submitted written testimony. It includes references to 2 articles that I've written in the past year that probably bear most on this. And those articles pertain to the questions about what the literature around parties is, political parties today, and the way they contribute to the weakness of American democracy and to responsiveness. And those are in my written testimony. So I want to step back from my written testimony to say that, especially in light of the previous testimony, I want to emphasize 2 aspects. One is I think that the current regulation is significantly, is likely unconstitutional, and that you would do well to amend the current charter before you face a lawsuit, because when you face a lawsuit, deregulation will be absolute. There will be very little opportunity to address the concerns that Councilwoman Jim in particular was articulating, and so you'd be better to correct course early rather than face litigation. And the second is that actually, with all due respect, I think that the primary concern with political parties today and the ways that they do not contribute to democracy is not the risk of a return of the party machine and corruption, but the atrophying of state and local parties and the channeling of that kind of political activity into super PACs, Indivisible, the Tea Party, sort of these extra party organizations that are in general more partisan, more polarizing, and really move the political parties away from the ability to compromise. So with those 2 sort of overarching themes, My overall view about this proposed resolution, which I have read carefully, as well as all of the regulations that implement them, although I would not say I was an expert on them, is that I think this proposal is a significant step in the right direction. In particular, I really appreciate that it preserves the limitations on campaign serving as a financial officer for a campaign or political party. It restricts government employees from serving as what I would call bundlers, sort of collecting campaigns money. I think those are the places where the risk of corruption is highest. And at the same time, it channels city employees into participating in ways that I think are extremely healthy for democracy, which are volunteering and peer-to-peer, but that's the term of art, organizing, so that you work with your social networks. And one reason I think that this is a significant step forward is that city employees, I think, bring a number of strengths to politics. They are likely to have broader social networks than many of the sort of college-educated, wealthy individuals who are running groups like Indivisible or participating in super PACs, but broader representative networks in terms of race, socioeconomic status, and age. That, I think, actually comes from the very fact of working for city government, where you work with a range of people from different places. They are likely to understand how government works at a time when Americans are deeply cynical about government. They are likely to see that government can not be dysfunctional. They are likely to be less hyper-partisan. That is a speculation, but I suspect that is probably true. And most controversially, and I know this is the source of this original regulation, they are likely to have access to key policymakers. And that, I would argue today, is the biggest problem with American democracy, is that unlike in the 1950s, when politicians were deeply embedded in their communities through unions, through churches, through the Rotary Club, through veteran status, and they went to community organizations, and they built their networks through social connections because they didn't have the same amount of money in politics. They didn't have the same need to depend on television. There were more opportunities for ordinary constituents to be in contact with their representatives. That was the upside of the patronage system. The corruption was the downside. I think regulations should be in place to sort of prevent a resurgence of corruption, but the upside of the old-style machine was that it grounded elected officials in their constituencies. The current system grounds elected officials in donors who tend to be from a particular class, and it is those donors who have access to politicians whose phone calls are answered. And even my presence here comes through social networks. It was because of connections between the law school and the city government that I was here. That is how politics works. I think that is an important part of being able to hear different perspectives, is to be able to rely on those. So I think city workers' access to policymakers is actually a significantly underappreciated asset. All right, I know you mostly want to hear what I have to say about the First Amendment, so I will focus on that. Let's talk about the current reform, the current city charter and its interpretation. I think the current restrictions on city workers are likely unconstitutional, and as I said already, and I will repeat, court-instigated deregulation will be far more blunt and will undermine any of the city's legitimate concerns in this regulation. I also think the current restrictions are extremely problematic from a democracy perspective. They limit government workers to participate politically in elections in the least effective ways. So although we often talk about the value of personal political expression and the value of being able to sign a petition or send out a small donation, the fact is political power comes from organization, and these regulations limit city workers' ability to organize through political parties and in campaigns. Again, I'm not talking about spending money. I agree with the restrictions on spending money. But the ability to restrict their ability to participate politically in the regular channels of election should not be underestimated, and I think that is the fundamental problem with the statute and its interpretation of the charter. And finally, as I said earlier, they channel meaningful political activity outside the official party and outside of campaigns in ways that likely enhance partisan polarization and the dysfunction of city politics and national politics. So, to put simply, I think the risk of the current city restraints is that it likely violates what has been termed the unconstitutional conditions doctrine. Under this doctrine, governments are prohibited from conditioning access to their largesse, which includes government employment, on the giving up of a constitutional right. In this case, the city of Philadelphia essentially forces its workers to give up their constitutional right to meaningfully participate in political parties and in campaigns in order to remain employed. I think the most egregious bar is actually the one that the current resolution does not go far enough toward, which is the restriction on participating in political parties. Now, that does not mean I think that one should abandon all restrictions. I think the campaign restrictions make sense, the bundling for parties makes sense. I think continuing prohibitions on city workers working as election officials or poll workers makes sense, but I think the restrictions on political participation, getting out the vote for a political party, or being part of the national convention where you might be part of the party platform, I think those should be considered to be scaled back because I think those would help our political parties. Now, as General Counsel described, there is, of course, a doctrine about government workers' First Amendment rights, and under that doctrine, the court distinguishes between situations where the government acts as sovereign and the government acts as employer. So where the government acts as employer, government workers have more limited First Amendment rights. And here the court distinguishes between employment-related speech, for which basically government workers have no First Amendment rights, and matters where they speak as citizens upon matters of public concern. Even when a government worker speaks as a citizen on matters of public concern, there is a balancing act where the city's interest in this case in an efficient, merit-based employment system would be balanced against the government workers' interest in political participation and speech. Still, most of the cases where government workers lose because they have under this Pickering test, which is the balancing case, are situations where government workers have been caught up in whistleblower situations or are aggrieved employees. This is not the kind of restriction that we're talking about here. Here we're talking about what the court has called an ex ante restriction, even before, unrelated to any specific incident. There's just an absolute ban on certain types of political participation. And the court in the United States versus National Treasury Employee Union, a 1995 case, said that the government's burden is higher when the ban chills potential speech before it happens. Indeed, in that case, the court struck down a far more limited federal restriction on government workers. In that case, federal employees were forbidden from accepting any compensation for making speeches or writing articles, and that was struck down. That is much narrower. In any event, if the city were forced to defend this regulation, it would have to show that it is narrowly tailored to one of two interests: maintaining an efficient merit-based as opposed to patronage-based workforce, or preventing quid pro quo corruption and its appearance. And I believe that it will likely fail if it is unable to show a contemporaneous record of concerns, that is, concerns not dating back to the 50s or the 19th century, but contemporary concerns. And in this regard, I will say that the city has defended this charter provision twice, not the ones that we're talking about, but the original charter banned, as I'm sure you know, fighters and police officers from engaging in any political activity. The city lost both of those cases. The thing I think that is most relevant from that is that one of the district courts, I think it was in the earlier case, with the police officers, expressed skepticism about the risks of a return to the kind of patronage-based corrupt system in the past, noting that the record demonstrated that while politicians frequently seek to pressure the police department, maybe it was the fire department, I'm not sure, they do, quote, they do not usually succeed in corrupting the fire department's admirable commitment to a meritocratic personnel system. So I think one of the issues is that, I assume all of you are Democrats, I didn't go back to check. The courts are, you are not an independent. Nevertheless, for those of you who are Democrats, the courts now are much, much more skeptical about regulation of free speech generally. I know I sound like I'm a free speech absolutist. Actually, I write about the freedom of assembly and largely not an absolutist when it comes to free speech. But the courts are very skeptical about efforts to regulate in the name of quid pro quo corruption or the appearance of corruption. And I think that means that they will be very skeptical about reliance on records from 50 years ago or longer. Now I will conclude with a little bit of positive news. There certainly is precedent upholding the analogous Hatch Act. That precedent, however, is from 1973, and the landscape of First Amendment doctrine has changed significantly. Let's talk about the First Amendment of issues with the proposed regulation, if that's okay, unless you want to ask questions now.
Well, there.
Yeah, okay. Now, you know what? Because she's raised a lot of legal issues, I think we have a couple of lawyers here who have some questions about that. I'm going to ask for questions for her first, and then if you want to move to the other two members, okay? Just simply because there might be some. Why don't I recognize Councilman O first, since he raised the question?
All right, thank you very much. I simply said that that was a lot of legal presentation, and it was, quite extensive, so would it be okay if we just kind of questioned you
Absolutely.
separate from the panel? So I do understand what you are saying. I have just a couple of questions. Based on the case law that you are opining upon, do you believe that it is a constitutional right for city employees to run for office without having to resign their employment with the city?
I do not like answering questions like that off
Yes.
the cuff. I would say on a spectrum of more and less defensible, I would say that restrictions requiring city officials to resign before they run for office is probably safer than what you currently have, which are much broader restrictions. And I think you would have to argue it in terms of the corruption rationale, and I think one would have to emphasize the risks of collecting campaign contributions while in office, that the risks of quid pro quo bribery in order to get the startup money to run for office would be high. That's how I would imagine it would run.
So Philadelphia has the most restrictive regulations when it comes to elected officials. They must resign at any point if they're going to run for another office. But my question is not about elected officials. My question is about your civil service workers, your non-civil service. Currently, if any employee, non-elected official, wanted to run for an office on their own time, not interfering with their job, they would have to resign their employment from the city of Philadelphia. Is that constitutionally permissible based on your research and knowledge? Or is that unconstitutional?
Again, I want to reiterate, I understood that to be your original
Okay, thank
question.
you.
So I think one has to think of these restrictions on a spectrum. I think if that restriction is part of a law like the current one, and you go before the court, courts tend to want to answer questions yes or no. They don't tend to sit and want to parse which parts are constitutional and which aren't. So if that is what you want to preserve, that is what I would write into to amend the charter to say we maintain the prohibition on current civil service employees' ability that the requirement that they resign before they enter office. I believe all of those are in the interpretations. But so I think what I'm trying to say to you is the likelihood of success on the merits depends on how broad the prohibition you offer the court in the first place. Because whether or not they believe that your interests are compelling or whether the interests are narrowly tailored to the restriction depends a good deal on how much you're restricting in the first place. So a narrow law written just like that, I think would be much more defensible and probably would pass constitutional muster. But I don't think you can count on a court to preserve that if it is faced with a challenge to the whole ordinance.
So let me be clear. I don't try to protect that. I just don't know if it's constitutional. I think it's unconstitutional, provided everything that we've discussed, that if a city employee who is not holding a high position of responsibility like police commissioner or something like that, I don't see the reason why they would not be allowed to run for office on their own time, provided they don't break any other rules. The next thing that I'd like to ask is basically your opinion has, to me, stated that the proposed bill is a step in the right direction, which is also a way of saying it's not there where it should be. What should it be?
Okay, so I actually was planning to speak on that. I think that the current bill is less vulnerable to the sorts of First Amendment challenges described, but I still think that in order to survive constitutional muster, this city council is going to have to develop their record to show that they have a genuine current need for this level of restriction in order to protect the merit-based system that has been established. I also think that you're going to have to show a record of quid pro quo corruption or the risk of quid pro quo corruption. So since Citizens United, as I'm sure you know, the court has a very narrow definition of what counts as the appearance of corruption, and it is likely, I didn't even get to this, but there is also a risk that this ordinance would be challenged as a campaign finance restriction. I would not want to defend the ordinance on those grounds because it is an uphill battle. But to do so, one would have to beef that up. And one of the things to address the narrowly tailoring is that there are a number of lines that this current reform continues to maintain that would need to be defended if it came to court. So one is the decision to maintain current limits for local campaigns. I actually think that is the most defensible line because I think a court might be persuaded, especially if you were in the box of defending this as a restriction on government employees' speech as opposed to a campaign finance restriction. I think a court would be persuaded that participation in local parties increases the risk of a return to a patronage-based and corrupt political system. I think the decision to subject political appointees and employees to the same requirements may be less defensible. I don't know, I know less about city government workers than you do, but I suspect that the court would think that the risks of corruption and patronage-based employment for appointees is higher than for employees once the merit-based system has been in place for so long. I also think that your earlier colloquy raises another line of distinctions that you might be worried about, which is the fact that the city school board is exempt from this rule, and to the degree the examples that Councilwoman...
Not anymore.
Oh,
I mean,
but
the school district employee, for clarification, school board employees are now considered commissioned officers, so
Okay.
we were under state takeover.
Okay.
And then the school employees, though, are under a separate system
Okay.
because they
So
are not
they're-
city employees. They
Right.
are not city employees.
I think all of the variation between workers who work for the government who have different restrictions and some of those who may have actually had their employment subject to corruption is going to make it harder to defend the line, just as a practical matter. Not impossible. I'm not saying anything's impossible. I'm saying it's harder. I think the most, to get to your big point, what is it that I think that doesn't go far enough? I actually really do think that you should consider making analogous changes to the limits on participation in political parties. I know this is very controversial, but with all due respect, as I said earlier, I think that the risks to our political system is that our parties are dying, not that they are too corrupt. And those might actually be connected. The more isolated what exists of local and state parties is from the electorate and its constituencies, the more likely that you are going to get old-style corruption. But I think the bigger problem is that there has been a resurgence of political activity in the last 2 years, and engagement, and a lot of powerful efforts to demand responsiveness and make change. And that is being challenged into these very weak institutions like Indivisible, and even unions, which are not weak, but actually I worry about having too much pressure on unions to do the work for ordinary citizens, because as unions are politicized, they will be undercut economically for their economic functions, as we've already seen. So I would not, just because in anticipation of some questions I might get, I do not think that you should repeal things like the ability of city employees to sit as like finance persons for political parties, or even maybe to run for elected office, although I'm not sure what I think about that. I certainly don't think they should be involved in bundling of campaign money or in election day activities where the risks of corruption are high. But I do think that they should be permitted to participate in aspects of parties where they could help shape the platform, and where they could, more importantly, organize, get out the vote, and other kinds of political engagement.
Thank you very much.
Councilman Green?
Thank you, Mr. Chair. I would be remiss in not applauding your years of service, not only in this body, but as chair of the Law and Government Committee. We've had many great conversations debating the legal ramifications of not only our home rule charter, but the laws and regulations of the city of Philadelphia, as well as the Commonwealth of Pennsylvania, as well as the U.S. as a whole. So thank you for your leadership and chair of this committee. Many of your activities have often been on the ballot, even when you are not on the ballot as chair. So thank you, Chair Greenlee. Briefly, because we've had quite a long colloquy on a lot of issues, but clearly what I get from your testimony, and thank you for being here, and I would be remiss in not looking at your testimony, the fact that you've clerked for Judge Edwards for the D.C. Court of Appeals, Circuit Court of Appeals, which is basically some would say the leading court on your way to the Supreme Court. So you clearly have a long history and knowledge in reference to First Amendment issues. I also noticed that you were able to get a JD and PhD from a university from the northern suburb of Philadelphia. So that's also quite a remarkable background. But what I gather from what you're saying is that because of recent case law, that this type of legislation would need to be narrowly tailored. And would that type of narrowly tailoring evidentiary background, would that come from rulings from the ethics board? Will that come from, I'm just trying to get a sense, what would be the type of evidentiary information that would be needed from your perspective to justify this type of legislation, regardless of which way it goes going into the future, that would help to provide the evidentiary information that's needed to show to a court that has been narrowly tailored to address a specific current concern, not a concern that goes back to when the charter was changed some 60 years ago?
So I think there are two elements. So first of all, I think that in Regulation 8, it is 8.7 that I think raises the broadest concerns. I think that is the least narrowly tailored of the interpretations of current regulations. And to the degree those pertain to political parties, I think they remain a risk. So if the city board, if the ethics board that creates Regulation 8 were to narrow some of its interpretations, like around get out the vote for political parties and so on, I think that it would be more narrowly tailored. At that, I presume that the commission has hearings or has, and in that process, if it were to enter into evidence sort of examples of merit, of current situations where there's been a risk of party patronage in these situations, that would be helpful. I think it would be best if that testimony happened before City Council itself, where people put into the record where the places that they are most concerned about undermining the now pretty well-established merit-based employment system. I do think City Council could consider beefing up its restrictions on the other end, which is that employees and those who exercise city office should not abuse their power to pressure employees to act politically, because that's really what the concern is. So I think two places. One would be in the actual interpretations. If the interpretations are narrower than the actual charter language, the court will analyze the interpretations of the charter, not the charter itself. And the record could be either before the board or before City Council.
Okay, and that would also include any type of decisions that the ethics board may have made regarding fines and violations of the charter.
Yes.
Right. That could be used as evidentiary information.
Yes.
Thank you, Mr. Chair.
Thank you, Councilman. Thank you for your earlier comments. I appreciate that. Councilwoman Gim, please.
Yes, thank you very much, Mr. Chair. And I'll also echo the same. It was a pleasure to serve with you for my
Thank you.
first term.
Thank you.
I really enjoyed it. So I'm not going to ask too many questions because I hope that at some point we'll be able to have a longer dialogue and debate, a panel perhaps at some point later outside of this room, so it doesn't have to be so restrictive in terms of the back and forth. But I did want to clarify a couple of things. One is that city employees are allowed to participate in GOTV efforts as long as they're nonpartisan. GOTV, by definition, is nonpartisan.
But they are not allowed to participate in partisan get out the vote, right?
Well,
So
they're not allowed to
allowed
participate in candidate-based voting. I think that's what's clear.
Well, here
They
it
are-
says, an employee may not participate in get out the vote activities organized or sponsored by a political party.
We can discuss this a little bit, but I think in general, I am also contesting your use of the idea that they cannot participate in GOTV. They can absolutely participate in GOTV. There is plenty of nonpartisan GOTV. I do not, I appreciate the fact that your concerns about indivisible let aside, but I'm fascinated by your adherence to political parties specifically as opposed to political activity. So we can go through that, and that's partly for longer down the road. But GOTV is nonpartisan, and we absolutely encourage, support, and want people to be active and engaged in registering people to vote, getting people out to vote, doing census work, et cetera, et cetera. I also wanted to ask, because you have a line in here.
I actually want to interrupt to just clarify one thing again on the question of the Supreme Court and the perspective you might have. So there is a First Amendment right of association. The Supreme Court is very interested in the right to associate with political parties. And so I'm not sure that a court ultimately would accept that the ability to get out the vote for a nonpartisan organization or for your union was an adequate alternative form of expression
I understand
to
that.
a prohibition on
I'm saying that
getting-
you had testified earlier that somehow we are not allowing GOTV efforts, and that is actually not accurate. I also wanted to, I think in your testimony you said most egregiously it bars all employees from joining political parties, which is also not correct. An employee can absolutely join a political party. It's just different if they are acting as an actor on behalf of that party. So I just think that that's not quite phrased maybe the way you need to, but we can go through that. I just wanted to put some of these clarifying things on the record. Campaign finance, in terms of they are absolutely allowed to donate. They cannot solicit donations on behalf of a specific candidate or a specific political, let me just leave it at specific candidate for right now. But they cannot do that. Yes, it is true. If you are the managing director and you hold a house fundraising party at your house and you ask or invite other city employees to attend, that would not be deemed appropriate for many reasons, I think, that are quite obvious as well. But I just wanted to clarify that in terms of campaign finance, they are certainly not restricted in terms of being able to donate as much as they want up to the legal limits as possible. Now, whether we go into other aspects of campaign finance, whether they're allowed to solicit, host fundraising parties, chair an actual a committee for an elected official, and then whether they can be evaluated fairly on merit-based employment. Like, I think there's a lot of gray area in there, and I think the courts would recognize that there's been gray area between quid pro quo, which I should be able to pronounce after all of this ridiculousness that's been going on, quid pro quo and merit-based employment. There's a lot of questions about whether someone's participation in political activity impacts their ability to be fairly evaluated on merit-based employment. Especially if that person could potentially
I
be their
just want to
boss.
clarify. I actually think that challenging this statute as a campaign finance restriction is the least likely. However, campaign finance laws include this issue of can you contribute anything of value, and to prohibit volunteering for a campaign or to prohibit phone banking, or those are all things that if you don't get volunteers, you have to pay for. So they are a thing of value. Presumably, this ban would also ban sort of research that somebody might offer a campaign about other officials. I think that would be very defensible under the government speech doctrine.
Yeah.
The information that you learned on the job you cannot use against your employer. But I just caution the council to consider that the legal landscape has changed dramatically since Donald Trump won the election and has stacked the courts, and that it would be foolish to walk in confident that one can defend the statute, because I do think that the underlying principle of merit-based city employment is a good one, and it should be accepted as a compelling state interest. I actually believe that the concerns about quid pro quo corruption and its appearance are compelling. I'm trying to help you save your statute, and the only thing I'll say for the record is that I encourage all progressives to notice that one of the mistakes, I think, of the progressive era was to believe that ideas were what motivated politics. Mm-hmm. People motivate politics, and to the degree that you take people who are politically engaged and knowledgeable and have broad, socioeconomically diverse networks and you say they can only participate on the outskirts of politics, I think you are undermining government. That is my personal view. You can take it or leave it, but that's the source of my concern is not a return to old-style machine politics. My concern is that we have lost parties, and what we have are groups like Indivisible that are great when they have one person who's motivated to keep them going and will fall away very quickly when that person passes.
I am not quite as sentimental as you are about parties. Political parties do rise and fall. But I will be interested if a Trump-stacked federal bench would be interested in taking on a predominantly Democratic city that would unleash the power of its city employees, of which we are the largest employer, in a political process. I would be very interested about whether they would take that on. On the other hand, maybe we don't have to get there, and in the meantime, I think we should continue to discuss this. This idea that the law has not changed since 1951 is not correct. I think as we discussed, there's both the written law and the interpretation of the law, and the interpretation of the law has continued to evolve. We have a pretty robust ethics commission that we are dedicated to supporting, funding, even when they are pretty restrictive on all of us, and we don't always agree, but we're really proud of it. And so, we will continue to be in this arena, but I really appreciate, the efforts and the work in this process, because I think it's very important and it helps to hear it all. So,
I really
thank you.
appreciate being heard. Thank you very much.
Thank you. Thank you very much. Okay, we have two more witnesses here. Again, no one else here to testify on this? Okay. Whoever would like to go next, please let the record reflect Councilman O'Neill, member of the committee, is present.
Good morning, Chair Greenlee and council members. My name is Dick Levinson, and I'm proud to be a librarian with the Free Library of Philadelphia. I wish to submit written testimony in support of Bill number 190861, which creates important new opportunities for city employees to participate in the political process when not on duty. A quick family history will help to explain why Councilman Green's bill is so important to me. My grandfather, Morris Levinson, fled Tsarist Russia for America because Russian Jews had no rights that the state was bound to respect. What Morris wanted for his family was not just the right to live in peace, but the complete catalog of political rights that come with being an American citizen. Let me be clear. For a city employee to engage in politics while on the job is not just illegal, it's immoral. However, for Philadelphia to strip its employees of their basic constitutional rights as a condition of employment is to strip us of our dignity, our humanity, and our pride. Am I really less of a citizen in your eyes because I chose a career in public service? Councilman Green's bill isn't perfect, but it represents a giant step forward because it begins the process of healing a grievous injury, one that should have been addressed years ago. Let's be honest. Nobody in this room is naive. Everyone here understands that our democratic republic has not faced such an uncertain future since the Civil War. Within the next decade, voters will definitively decide what America really stands for. The question about whether our nation can be a source of responsible moral leadership for a troubled world will be answered. We will have to reckon with the matter of whether we possess the humanity necessary to embrace those whose language and skin color are different from our own. Make no mistake, a great political battle for the hearts and minds of the American people is coming. As you know, this battle will be fought in precincts, wards, and counties throughout this nation. Every thoughtful person must do his or her part. Please don't send us into this fight with our hands tied behind our backs. Thank you.
Thank you. Thank you, sir. Mr. Christmas? And we have your written testimony, so we're going to be butting up against another hearing pretty soon, so thank you.
All righty. Good morning. Yeah, because you have my written testimony, I will refrain from reading verbatim everything we have here. So, yeah, my name is Pat Christmas, Policy Director for the Committee of 70. Very happy to be here this morning to speak on the proposed amendment that we've been discussing for the past hour and a half. And, first I'd note, again, I was in this chamber just last week and stressed how much progress the city of Philadelphia has made, not just over the past 7 years, but over the past 15 years in particular. And this progress has been made by putting in place stricter, more robust rules, along with the appropriate enforcement and interpreting your regulations. So the fact that we are talking about potentially loosening some of those rules, I don't think is necessarily a bad thing. In fact, I think there's a case to be made here. And so, in my written testimony, we've outlined from 70's perspective some substantive questions, concerns, and then several that are on the implementation side. And the first is simply this. I mean, has the city made enough progress so that our public officers and employees on their own time and on their own dime work directly for political campaigns? And I think, if when it comes to a statewide attorney general's race, is there enough distance between that and what someone's doing on a day-to-day basis, in their city job? I think that's probably the case. Frankly, if there's a concern, I think would be less around someone's client-facing interactions with a member of the public. It'd be more what sort of pressures or incentives might come about in the workplace that would be unhealthy for our public employees. So that's the first kind of big threshold question, right? So the second one is, and I think this amendment has actually been fairly very cleverly written to allow a division between federal offices, statewide offices elected on a statewide basis, any other non-local offices, folks going out to work for a county commissioner election in the suburbs. Is this line in the right place? The one office that caught our attention in particular that would be allowable if this amendment were to go through is U.S. House races, right? I mean, our U.S. congressional members have deep roots in the neighborhoods and in their communities, as they should, in our local politics. And is that, of all the races that would be uncovered under this proposed amendment, should that be one of them? Have to note that one of our longtime congressional members remains the 33-year head of the Democratic parties, head of the parties for as long as I've been alive. Just the point being that local politics, especially for that office, are still very much closely entwined. Another substantive kind of question for us to consider is whether or not this should look the same for all employees. As we just discussed earlier, the Federal Hatch Act has multiple tiers. The most restrictive tier is for those federal employees and officials for whom you'd think, they have pretty strict rules because their duties are so sensitive. But we also here in the city of Philadelphia have higher-ranking officials whose work is also politically sensitive. I mean, if this amendment were to go through, for example, the Board of Ethics members, their staff, city commissioners, not the city commissioners themselves as elected officials, but their staff, would also be able to engage directly in political campaigns. Now, I'm not sure if Mr. Cook would be jumping straight into a political campaign if this amendment were to go through, but that's the kind of thing that we'd want to consider. And another is that whether or not there's a distinction between not nonpartisan, but partisan GOTV work directly with a campaign, right? The canvassing, the phone banking, whether there's a difference between that and participating in a campaign at a higher level, right? Whether there's some title attached or whether we have a city official who's bringing their expertise from their day job, their policy expertise, their political expertise into that campaign. Right, having, for example, one of our high-ranking transportation officials drafting a transportation policy paper for a campaign, with or without their name attached. Of course, their title would not be attached. But is that the kind of transference that we think would be okay? Moving on quickly to a couple just the implementation questions, challenges, concerns that I think, again, would have to be hashed out before this would go to the ballot and move along in this body is, whether or not we have a clear enforceable boundary. That's an essential question anytime you pass a new bit of a regulation is, can you enforce it fairly and cleanly? We do have a lot of rules in this town for good measure around campaign finance, around city contracts, and our ethic rules are quite extensive and quite complex. And that has created training and enforcement challenges, I think, for our ethics officials. Now, they work extremely hard. The ethics board, our chief integrity officer, both for the administration, for city council, the inspector general's office, I mean, they run trainings constantly. They make themselves available by phone, by email, by social media, but still we have 25,000 city employees for all of whom these rules apply, and as much as our ethics official staff stress, if you're not sure, ask. Even that simple message is difficult to get through sometimes. So, if we were to put these rules in place, again, the question is, can they be enforceable, and can folks keep them in mind enough to at least ask the question if or when they need to? So. And this would not be easy, right? If you're caught up in the middle of a electoral campaign, that's a fast, intense experience, and our folks are going to bear in mind the difference between one of our local offices that they would remain unable to participate in, race for at-large council, for example, and a presidential or gubernatorial race. The example I give in my written testimony is the fact that the Elizabeth Warren campaign endorsed Kendra Brooks, candidate and now council at large elect Kendra Brooks for office. I'm not certain, actually, off the top of my head, whether or not those campaigns did any joint programming, events or JOTV or anything else. But will our public employees be ready to identify that possible issue and then navigate it? The other is that, in a separate paragraph, not the one that proposed to be amended in this particular resolution, but the prior one, remains a prohibition on fundraising, which also was discussed already this morning. 70 believes it is essential for that fundraising prohibition to remain in place. But again, in the heat of a political campaign, will our officers and employees be able to make the distinction between that phone banking, that canvassing, whatever else is happening in the campaign office, and the solicitation of campaign funds, which would be legal, and we would not want to set folks up for accidentally tripping over these rules. In sum, again, I think my sense is that some of the same questions and concerns that our board members have been mulling over, I know the Board of Ethics members and staff have also been thinking through. Councilman Green and his office, I know, have been thinking through these for quite some time. And overarching message, I think today being the one that's already been noted, that we have these questions, concerns penned down before we give this question to the voters. So I'll pause for there, and if any questions you have, I'd be happy to field them.
Thank you all for your testimony and your taking time out to be here and talk about this issue. I think it's an issue that will engender more conversation, discussion, and something that I think needs to occur. Part of the reason why I think this has not been challenged, because there has not been a city employee that was willing to risk their employment to challenge this legislation and the charter. In addition, even if they were to challenge, it would take some significant resources, and they probably are not in a position to do that as well, unless some individual organization decide to do it on their own merit to support that type of litigation. So that's why I think part of the reason why this has not been challenged in the years past. I've often thought it is provide some, I won't say unconstitutionality, but does bring some concerns in reference to freedom of association and First Amendment issues. And I think by having this conversation, we'll have an opportunity to continue the dialogue as we move into the new year to try to continue to improve this legislation. So I want to thank everyone that came to testify today, and we'll continue to have this conversation on a very fruitful and engaged topic. So thank you. This hearing will be recessed to the call of the chair.